Thank you so much for tuning in. This is attorney Matt Wayman here to chat with you about preliminary hearings. What are they? A preliminary hearing, also known as a probable cause hearing, is where the state puts on evidence to establish probable cause that a crime was committed. So all felony cases in the state of Missouri start off at the Associate Circuit Court level, and they get to circuit court by one of two ways: by preliminary hearing or by a grand jury indictment. Higher level cases like sex cases, domestic violence cases, shooting cases, those would go to a grand jury generally. And lower level cases like stealing, possession of a controlled substance, tampering with a motor vehicle, those would generally go to a preliminary hearing. The standard at a preliminary hearing is preponderance of the evidence, so think 51% over 49. It's generally a low bar. At a lot of preliminary hearings, if the state can produce their witnesses, victims, or police officers, the court will find that there was probable cause that a crime was committed. So the state would call police officers, victims, witnesses, and they would get on the stand and testify to either what they saw, what happened to them, or for police officers, what they did during the course of their investigation. And then the defense attorney is allowed to cross-examine those people as to what happened during those series of events. So think of it kind of like as a free deposition. It's where you get to cross-examine the witnesses that would later testify at any trial against you prior to that trial to basically ascertain the strength of the state's case prior to even getting to circuit court. Cases also get dismissed at preliminary hearing. If you appear with your attorney, whether it's a public defender or a private attorney like myself, and the state announces that they are not ready to proceed, I would object to the continuance that they are requesting. And if that happens 2 times, the second time, if they cannot come up with a good reason as to why the judge should grant their motion for a continuance, I would move that the case be dismissed for failure to prosecute, and the judge would toss the case out. This does not mean that the state cannot recharge the case later, but the case as instituted at that point would be dismissed for failure to prosecute because they could not produce the witnesses that they needed to establish probable cause 2 separate times. It's not a hard and fast rule. If the judge decides that the reason that the state set forward was a good reason, the judge can give them another couple continuances to get their people there. But we found through practice, especially in St. Louis County, that if they cannot produce their witnesses or victims or police officers after 2 settings, the cases will generally be dismissed after we object to the first continuance and move to dismiss it after the second continuance request. I hope this video has been helpful to chat with you about preliminary hearings and what occurs at preliminary hearings. If you have any more questions about what occurs, just comment down below. If not, I want to thank you all so much for watching. We're going to be back soon with more videos.